Do that now. Hello and welcome. My name is Codie Chisholm. I'm a lawyer with the Research and Opinion group with Lawson, Lundell, and just newly called to the board or bar about an hour ago. So thank you very much for inviting me today to come speak with you about the law refresher on privilege. Joining me remotely from Vancouver is another one of our Research and Opinions partner, Catherine. Do you want to? Are you still there, Catherine? Catherine. Uh-oh. Give me a second here.
Just realized that I think that that's the camera.
It's moving. It's moving all over the place.
You're gonna catch my mess.
Give us a second here, Catherine. Leave her on the list anymore.
Yeah.
It's dropped off. Oh, we got one more joining us. Just let me send her a message. Uh-oh. Zoom just crashed. Okay, well, I'm gonna get started. And hopefully she'll join us. Catherine's been at Lawson for several years, I think 8 or 9 at this point. Was former with the Alberta Court of Appeal, and then before that, a national law firm in Calgary doing litigation. And so today's presentation we're giving to you is one that we've done internally at our firm on class privilege. Just let me exit out of this. In light of well, this isn't a touch screen. In light of the mixed group here, we're touching on a few different class privileges today. We'll be touching on solicitor-client privilege, litigation privilege, and informer privilege, because there may or may not be some crown. We will dabble a little bit, although I know that is dangerous in some of the criminal law principles. If I hit delete, is this going to exit out of entirely out of Zoom, or what are we doing here? Give me a second. Okay, let's do this. We'll also talk a little bit about waiving privilege and something called common interest privilege. So at a very high level, there's 2 categories of privilege. You have your class privileges, which have been recognized by the courts. You don't need to, have the whole argument as to whether or not they exist. They cover communications or relationships, solicitor-client privilege. Like,
Do you need to have the screen now?
I think we're good. Yeah, Catherine just crashed, but she's hoping to join me soon, hopefully before her slides start, because I didn't read them. Okay, and then case by case privilege. So we won't be getting to case. There's a lot to talk about. For privilege, we did ask for an hour and a half of your time, which will just get us through today's topics. But case by case, that's the Wigmore test, the 4-part test for solicitor-client privilege, where you could have on a case-by-case basis, the establishment of a privileged relationship. So you may see, although they haven't been successful, the patient, doctor-patient, priest, penant, those types of relationships where you can maybe try to take a run on privilege existing in those unique circumstances. Unfortunately, we won't get time to talk about other types of class privileges like spousal privilege, privilege against self-incrimination, public interest privilege. We will not deal with, unfortunately, parliamentary privilege. I got a memo on the system for you though, okay? So you're good. A qualified privilege, so the defense and defamation that could potentially be raised. Not going to be able to talk about any of those today. Oh dear. Okay. Her entire internet has gone down. Wonderful. Okay. These are really good resources, particularly the Hubbard text. That's the one that we've used mostly for the cases and the principles. That's a big loose leaf series. If you have Westlaw, you could get online access to it. It has all the leading cases, the principles, and some of those unique, novel, weird situations that you may come across in your practice. Adam Dodek, that text is getting a little bit old, but he is one of the leading Canadian experts on privilege. Of course, just the law of evidence from Sapinka, and that last one there, I'm not as familiar with it. It is looking a bit dated, but I think Catherine maybe had been using it. So we're gonna talk about privilege today, but we need to put privilege within the kind of the greater context of confidentiality, privacy, and some of these overlapping concepts. So the right to privacy and the right to confidentiality go hand in hand in some sense, and they might lead into information having a privileged status, but they are not sufficient in and of themselves. And so remember, we have a duty, a professional obligation of confidentiality as it relates to our client communications and those sorts of things. And then we also, as businesses, are in possession of information covered by privacy laws, so personal information and laws governing the use and disclosure of that. So just to be clear that even though you may have something that is private or confidential, that does not make it per se privileged. Okay. So what is privilege? Privilege is basically these principles, these rules of law, where we as a society has said that the public interest in protecting the confidential nature of the relationship outweighs the public interest in obtaining evidence to help resolve a legal dispute. And actually, that's how we settled on the class privileges we're talking about today. The ones that are most likely to be engaged when you're in a trial or trying to deal with discoveries or disclosure or something like that, okay? You can raise it in a variety of different situations. It can be raised not only in court, you've got your FOIP requests, so there's statutory provisions dealing with privileged information, as well as any sort of like other types of legal relationships. We'll talk later about a British Columbia case relating to documents by Strata Corporation. There was a carve out for privilege or legal opinions that in those statutory regimes. And then of course, CRA, the CRA stuff is where we've had some of our best kind of cases coming out on the solicitor client privilege, where the government is trying to come into our offices and take our clients' information without having the requisite protection. So we'll talk about some of those cases.
Codie, I'm good to go now. Sorry about that.
Fantastic, Catherine, welcome back just in time.
Yeah, the whole internet went down, but somehow by restarting it, or just my computer, it worked. So I'm just gonna.
Fantastic. Are you ready to jump in on categories of privilege here? Slide 6.
Absolutely. So long everyone can hear me fine?
Yep.
Perfect. All right. Yes. So as Codie mentioned, there are currently 2 recognized categories of privilege. There are relationships that are protected by a class privilege, and relationships that are not protected by a class privilege, but may still be protected on a case-by-case basis. You have to apply what's known as the Wigmore test. So this is a set of criteria for determining whether communications should be privileged and therefore not admitted in a particular case. And due to the interest of time, we don't get into the Wigmore test, but we wanted to mention it here. For a relationship to be protected by a class privilege, it must fall within a traditionally protected class. So for example, solicitor-client privilege. And there's an extremely high threshold for recognizing common law class privileges. And this means that to date, there are only 3 relevant to commercial practice that have been recognized: solicitor-client, litigation, and settlement. New class privileges, they can be recognized only if they're supported by policy rationales that are as compelling as the existing class privileges. So solicitor-client, for example. Parliament, the legislature can create class privileges by way of legislation. It has done so. Just as an example, public interest privilege. And it's important to note, lawyers often forget to check subject matter legislation and applicable evidence act for any sort of legislative articulations of privilege. And that's where you would find where the government has gone ahead to do that. All right, moving on.
Okay, so the biggie, right? The one that is engaged in all kind of aspects of our practices, the solicitor-client privilege. Well, not all of them, maybe some government lawyers here. So we'll talk about that. So we've got a bunch. So this is one of the oldest recognized privileges, and you'll see it dating back to the 16th century. Different rationales have been put forward as to why we have solicitor-client privilege. So it used to be, the honor of the profession to keep secrets. And then it sort of slowly evolved in this idea that we need to have full and frank disclosure from our clients so that we can help them navigate some of the problems and the challenges that they may face. It's also been cited as promoting well-functioning adversarial systems. So we need to have that free flow of information, access to justice. There's just been a whole bunch of really critical statements from the SCC, particularly between 99 and 2002 was a quintuplet of cases or quintology of cases. So they elevated it from a rule of evidence to a fundamental civil and legal right, kind of preeminent constitutional right under the Charter of Rights and Freedoms. So that was your National Post case from 2010, SCC 16. So they described it as one of the most ancient and powerful privileges known to our jurisprudence, as generally seen as fundamental and substantive rule of law. So it is currently best understood as a quasi-constitutional right to communicate in confidence with one's lawyer. So it comprises the protection against voluntary or compelled disclosure, absent the client's consent or court order. And it also includes the protection against the client being compelled to disclose information covered by the privileged. So the other thing to keep in mind that it must remain as close to absolute as possible. And we're going to talk about kind of exceptions, exclusions, those sorts of things later. Another important case from that group is the Thompson case, the Canadian National Revenue 2016 SCC 2021. We're going to be talking like some imagery to help keep the different relationships in the continuum of communication kind of clear when we're talking about these different types of relationships. So solicitor client, we're going to talk about it being to visualize, close your eyes. Two kids playing with two tin cans linked by string. And so the whole communication, facts, information, what have you, that goes along this is covered by, it's broad, covered for the purpose of seeking legal advice will be covered by privilege. So another fantastic case if you're looking for like, you love it when sometimes these judges pull all of the principles together and then there's this one case that has all the sites. It's an Ontario case, 2022 ONSC 4675. Starting at paragraph 45, it is just every leading Supreme Court of Canada case where you just need that zinger, to put in your brief. You can go there to get all the SCC sites. Okay. So it is our professional duty as a lawyer to maintain. We can't waive it, right? Only our client can waive it. So, those top principles there. We have to claim privilege on behalf. What else we got here? Right. And we'll talk about some of those tax cases later on here and a current one before the British Columbia Court of Appeal or British Columbia courts anyways. So what do we mean when we say solicitor client privilege? There's a test, right? It has to be communication for the purposes of giving or seeking legal advice that was intended to be confidential. And so usually those first the confidential and some of these elements of the test are not very controversial. There's not a lot of cases about it, right? Like they give an example, don't give legal advice at a cocktail party, right? Like as students, you're told be careful with elevator talk and things like that, because you may end up in a situation where your communications aren't going to be covered by privilege because of the public nature of your discussion. So, so you have the presumption, the continuum of communication rule. So there was this, and some of the cases you have to be careful, particularly out of Ontario, they have this, but if its facts exist independently of the, your communications with your clients about the facts for the purposes of seeking legal advice are protected by privilege. If the facts exist independently, there's different rules that deal with, giving a document to a lawyer does not necessarily make it privilege, right? Like there's things that people will try to do to blanket everything with privilege, but for the most part, even your collection, notations or not notations of those publicly available documents are covered by privilege. I mean, the client still may have to produce them if they have them stored, right? It's electronic. There's copies of everything everywhere, but your copy of it will be covered by privilege. So, yeah, so just be careful with, again, there are some of these older cases where they're dealing with like unprivileged facts and stuff like that, I wouldn't really be too concerned about that, with the exception of people just providing you things to try to get the blanket privilege, right? But then it's not being provided for the purposes of legal advice. So again, that Ontario case, it's the Wintercorn of Global Learning, a ton of summaries of all the leading British Columbia, Ontario, all kinds of authorities in there to help you navigate, particularly how to deal with public or pre-existing documents, and navigating those type of things. The other one, we've got a good federal court decision, 2013 FCA 104. So that one talks about, how to reconcile the continuum of communication with those pre-existing facts or public documents. Okay. So legal advice.
Question, these various sites that you've got there, are those going to be available there?
Yeah, we can provide it. I mean, the presentation will be recorded, but we can talk about circulating copies with our speaking notes later, if that'd be helpful. Yeah. Yeah. Okay, very good. Yeah, well, there's so much law in this area. I just want to be like, in this case, in this case, in this case, but we want to make sure the leading cases and the best authorities. So, okay, legal advice. Objects aren't, like physical objects are not privileged. Catherine will talk a little bit more about the policy business distinction between privilege, because some of us in-house government may wear multiple hats, right? Us in private practice, it's a little bit easier. I don't have to maintain separate files for the different type of work that I do. But depending on kind of your practice, it may look a little bit different. Okay, so also acts aren't privileged. Who is the client? Okay, so the client, this area of the law has been informed by our code of conduct, which has a pretty broad definition of who the client is, including people who think they're our clients, kind of on a reasonable basis. In the cases, you'll sometimes see the solicitor-client privilege or the solicitor-client relationship arise and privilege over the communications on these, 30-minute consultations. So if that's part of your practice, sometimes you can get in a little bit of tricky. People try to gain that. Divorcing spouses, there's a lot of cases where that has happened, where they'll try to conflict them out by you picking up the phone and they just vomit information at you. Your agent, right? So the people in your offices, this can also happen with your reception or legal assistant or someone who answers the phone. So everybody needs to be really clear on how you're going to best manage those. Yeah, important that it's not just the formal retainer relationships, right? So kind of broadly. Confidentiality, not a lot of jurisprudence on it. Suggestion in Hubbard in particular that you'd probably be looking at what would be expected on a reasonable expectation of privacy. It's like the Section 8 Charter jurisprudence would help inform that. Basically, but it's intention based, so you're not really always dealing with kind of extrinsic or direct evidence about this. It would be surrounding circumstances and kind of what would be reasonable. Objectively reasonable in the circumstances. So, the indirect communications, this was an Ontario case that we had here, where it was communications with a secretary. And so then it was a husband and wife dispute. Okay, Catherine, over to you. Tired of talking.
All right. So the third party communications, this is one of the most misunderstood aspects of the law of privilege we found. And really, we wanted to include these slides because if a client is wanting to share your advice with a third party or get a third party involved in meetings with you, an alarm should start to go off in your head and you should start to think about privilege and whether, what to do in this particular scenario, because solicitor-client privilege extends only to third-party communications that are in furtherance of a function essential to the existence of the solicitor-client relationship. So it's sort of a theoretical, it's easy to think about in a vacuum, but it's sometimes difficult to put into practice. So, for example, communications made to or by third parties who are classified as agents of the lawyers or the client will be protected by solicitor-client privilege. For example, if someone is acting as an interpreter of information provided by the client for the solicitor, serving as a conduit of advice from the solicitor to the client, conduit of instructions from the client to the solicitor. There is no magic in a lawyer retaining a third-party expert, for example, like an accountant. You need to ask, is the lawyer retaining the third party because their input is going into the legal advice that the lawyer is giving? So again, examples: a translator, a family member assisting an elderly client, an engineer explaining technical aspects of a client's problem to a lawyer. There's always a risk in sharing solicitor-client advice with a third party, even if they have a relationship with the client. And we'll get into waiver of privilege a few slides down. There's a good Saskatchewan Court of Appeal case. We could also provide, if anyone's interested, it's Redhead Equipment, and it dealt with very commonly held misconceptions about a lawyer retaining third-party professionals and whether that will automatically clothe their work product with solicitor-client privilege. Also, misconceptions around having a third party provide information to the lawyer and whether that somehow invariably results in material being privileged. It's a good case. It's cited often. In this particular case, what had happened was a business restructuring, which led to the business to seek legal advice from a law firm. And at the same time, the business was engaging the assistance of some accountants to provide the necessary facts to allow the law firm to then provide legal advice. And so the issue was to do with whether these accounting documents were subject to solicitor-client privilege. So it's a good discussion. All right, moving on. So really, if the third party is simply authorized to gather information from outside sources and then just pass it on to the solicitor, or really just to act on legal instructions from the solicitor and providing specialist advice of their own, there's a risk that the third party's function is not essential, unlikely to be protected. And I mentioned Redhead Equipment here. So really, we owe this imagery actually to Lisa Peters. She came up with this, but she said that an argument that a solicitor and third party and the client, the communications between them are somehow privileged because the lawyer is driving the bus, everyone's on board and traveling towards the same destination. That is unlikely to succeed just on that sort of bare basis alone. There isn't anything like accountant-client privilege, no transactional solicitor-client privilege for third parties in a transaction. Really, what has to happen is that the third party has to be situated on the string, so the tin can string imagery, based on this functional test of solicitor-client privilege. All right. Moving on. Turning now to government and in-house counsel. So solicitor-client privilege, obviously, it can arise when government lawyers give legal advice to client departments or agencies. As Codie mentioned, if an in-house lawyer is conveying advice that would be characterized as privilege, the fact that he or she is in-house doesn't remove the privilege, but privilege won't protect policy advice provided outside the realm of a lawyer's legal responsibilities. So it's important for in-house counsel to try and wear one hat at a time, segregate communications giving legal advice from communications giving business advice. And the SEC case that's very commonly cited in the context of government lawyers and solicitor-client privilege is Pritchard and Ontario. It's 2004 SCC 31. It's a good decision. It's in our notes. We can certainly share it.
And if I can just want to add one thing, because I had to look into this last week on a policy a lawyer was put forward, a legislative drafter for a policy. They swore an affidavit, they sat for questioning, but some of the questions started delving into something that may look or was trying to get at kind of legal advice. And so the argument was, well, you put them forward as like a policy in their policy capacity. But according to Pritchard, when it comes to something like that, every single question and objection needed to be considered. It's to what hat they were wearing right? Because we were talking about a series of advice, research, documents prepared over months or years. And so it wasn't just enough to be like, oh, well, they're the policy person. It's like, well, they're also a lawyer too. And some of your questions maybe cross the line here and there, or were properly objected to on the basis of privilege. So it really is that Pritchard case talks about having to look at it on a case by case basis, considering the nature of the relationship and the scope of the advice provided at that time. So it can get to be quite onerous to navigate the policy legal advice divide if you're in a position where a lawyer has to be put up as a witness. So.
Yeah. So just some examples of when the issue of solicitor-client privilege may arise, obviously in the context of litigation, document discovery, questions asked in discovery, when a witness is being questioned, search and seizure in a counsel's office. So when the police arrive at a law office, a balance has to be struck between the public interest in the ability of the police to search the lawyer's office and then the interest in maintaining solicitor-client privilege. Now, we do have, there are guidelines for law office searches that are put out by Law Society. So that's sort of the first thing to look at when dealing with this situation. Also, you see solicitor-client privilege issues arise in the context of access to information requests. Note that the legislation actually incorporates solicitor-client privilege. Now, this topic alone could be its own presentation. So this is quite a superficial look at it, but we've tried to include just a note there. We also wanted to note that this issue could arise in the context of communications between Crown Counsel and the police. There's no question that solicitor-client privilege can apply to communications between the Crown Counsel and the police, but it doesn't automatically apply to any and all of those communications. The court in that decision we've cited there notes that the working relationship between the two leads to all different types of communications. So again, you fall back to the Pritchard decision, and each claim of privilege has to be assessed on a case-by-case basis.
I just want to talk a little bit here about Sherman Estate, which was the reformulative of the, depending on when you went to law school, Degantis and Mentec were the sealing orders. So this is the test that applies whenever you're dealing with a discretionary statutory common law, court's common law jurisdiction to provide any sort of court access restriction. Is a big umbrella term that could be sealing order over the file, document, pub ban, identification ban, those sorts of things. And so based on the three-part test, if you for some reason need to disclose information covered by solicitor-client privilege, you'll meet your first element of the test. But what we found really interesting is that there's it makes perfect sense. We've got a British Columbia Court of Appeal decision 2022 BCCA 28280 that when it comes to the proportionality concern, like it's not enough for the parties merely to consent to what they think the appropriate court access restriction is. The court needs to go in and make sure that that proportionality restriction is appropriate in the circumstances. And so again, you're taking a bit of a gamble if you've got to rely on privileged material to make your case and you're trying to do your best to protect it as best you can from, broader disclosure. I mean, you got to do what you got to do, right? But the court will want to sit in and give some a thoughtful attention, probably more so than maybe some other consent orders that you would have going to court, where maybe more just a little bit of a rubber stamp. And because in this case, they did not, the British Columbia Court of Appeal did not allow the broad and far-reaching pub ban or confidentiality order that the parties had agreed to, so they scaled it back. So be aware. Yeah, another Alberta Court of Appeal, 2022 ABCA 233, same sort of thing. The court weighed in and said, no, under the proportionality, this can be scaled back. So just be careful. Okay, when does it end? It extends a really, really long time. Once privilege over to privilege unless waived, so survives the death. We'll talk a little bit about wills exceptions and things like that. Survives bankruptcy or assignments in bankruptcy. Yeah, and so the difference then with the litigation privilege where, you know, lasts to the end of the dispute or, you know, maybe related disputes that can arise from it. Where that seems to have a bit more, and particularly if you're a litigator, then you're going to have usually both types of privileges layered on top of each other for a lot of what it is that you're doing. But this one is the oldie, the goodie, the longest, the broadest, the best. Okay. So exceptions and exclusions. So I've broken it out. Some of them will talk about the broad exception. It's not really an exception because it was never privileged to begin with. Your communications that facilitate or help your clients commit a crime are not privileged to begin with, right? Because we facilitate the giving of legal advice for legal actions, conduct, whatever, not things that are crime. Again, be careful. There are some cases out of Ontario where they're just, it's getting a bit broader, like it's becoming crime adjacent, which may be a little bit more uncomfortable because sometimes, I mean, we don't counsel our clients necessarily to commit torts, for example, but sometimes this is inevitable with breaching contracts and those sorts of things, right? And so having a too broad exclusion to include things that would be other than just like crime, fraud proper is a little bit concerning. But in any event, the crime one, now, when we give this in British Columbia, this constitutes is your ethics requirement for the year. So don't commit crimes.
Yeah.
Now you can check off an hour and a half of any sort of where you're keeping track of that. The exceptions are interesting. So the first one they teach you in law school, if you've taken ethics was mandatory when I went to school, but this clear, serious, imminent threat to public, that's the Smith case. Where they were very concerned that this person was going to go and commit a crime against an identifiable person or group of people. So not just generally they're dangerous. It was like they have formulated a plan to carry out this act against this person. So it's pretty strict. Innocence so the innocence of accused is at stake. That's one that applies to client privilege, and it's the only exception to the informer privilege, which we'll talk about in a little bit. So that's the innocence at stake. Hold on, let me find my notes on that because that's the one I'm a little less familiar with. So we're dealing with really wrongful convictions. It's not their statutory right to make a full fair defense. It is something where they're actually looking at a risk of being convicted because there's no way to get the evidence in another way. And it would be, you know, determinative. The lawyer regulation and the lawyer self-interest exception is interesting. So under our legislative regimes, like our Law Society regimes, there's a statutory provision in there that says, right, if they've got to investigate, a client makes a complaint, then they can get access to our files, right? And so it's kind of loosely based on an implied waiver of the client, or maybe we formally get them. I'm not sure kind of how it works here, even in Alberta, but for the Law Society to be brought in under our cloud of privilege is a little exceptional, but nobody complains about it because usually it's the client that instigated the request, right? So they would be the ones that would be upset. Our ability to defend ourselves as well, right? So if we get sued, we're able to pull out and rely on the materials in our file in our defense. Will's exception, you know, if you're holding on to the original will and your client dies, then you're able, I mean, technically it's a privilege to be like, I've got the will and, you know, here's what it says. So because you are thought to be carrying out, you know, the wishes and acting in your client's best interest by bringing forth the will, that the law has, you know, relapsed privilege around that. And so that's the Geffen and Goodman estate case that's taught widely at school. Now the exception stuff is interesting because the privilege is a limited exception for that limited purposes. So you, depending on what ends up happening and how broadly this information becomes public, you may still be able to protect it. In other instances, it's just for a particular whatever, a process, a particular third party, whatever you have to share the information with. So again, it's important, I think, in my mind, how exceptions and exclusions are not the same thing. Okay.
Two question, Cody. What if a lawyer is not licensed to practice in a jurisdiction, which is something that we come across here all the time in Northwest Territories, where we have a.
There is a rule around that. I just can't remember what it is. Catherine, do you know?
I think it's not privileged. That was my
Yeah.
understanding.
So privilege cannot attach to communications between a lawyer and client if the lawyer is not licensed to practice in that jurisdiction.
Yeah, well, I think if you're looking to take it into court, I suppose, right, Catherine? That would be the,
Yeah,
yeah.
yeah. I also have notes saying this, but I just can't find them right now.
Oh, yeah.
Yeah,
Yeah.
it's an interesting one.
Yeah, just remind people about it.
Yeah. Okay, okay, so there could be legislation limiting solicitor client privilege. These were the tax case, so, or the Ontario or the Quebec, 2016 SCC 20 and what's the other one? The Thompson case, 2016 SCC 2021. So these were challenges to the CRA's regime, where they were going to go in and take all of our stuff. So the SCC said, yeah, I mean, it's possible to do it, but the burden that they have put forward is like pretty onerous. And so I'm not sure that there's really been any successful, although we've got currently something going on in British Columbia where they were Bill C-47, an extension of a lawyer's reporting on reportable transactions and notifiable transaction. There's mandatory disclosure rules in that. Currently, there's a national injunction that we don't need to comply with it while it makes its way through the court, but they keep coming after our stuff. So we're going to keep having this fight, I guess, until the federal government gets the magic words right. We'll see. Whether they meet that threshold. There was a really almost comical case. Well, I thought it was funny. British Columbia Court of Appeal 2024 BCCA 89. This was the disclosure of the strata documents. And so it was listed as one of the documents that an owner is entitled to are the legal opinions of the corporation. And so the corporation was currently involved in litigation with this other group of owners related. They had a baby, and apparently you're not allowed babies in the strata corporation. So they're trying to kick them out or something. They had an ally, another board member or another owner who requested that legal opinion. And so apparently the fact that owners could get access to legal opinions did not include legal opinions covered by privilege. So therefore, like, all legal opinions are covered by privilege, but anyways, because they didn't say expressly legal opinions covered by privilege, they didn't have to prove that opinion. I mean, in the facts, everybody knew what was going on, so that was probably the right answer, but in terms of their interpretation of the statutes, like, okay, like, it seemed a bit far. So if that isn't even, I don't know where these magic words are that the SCC says are potentially to, you know, require disclosure of it. So we'll see what happens. So yeah, be mindful of it. We need clear, I mean, if you, anytime you're dealing with a statute, I mean, take a run at this by saying it's not clear enough, you know, however clear it might be, but it might be not clear and ambiguous. Or some ways to get around it. So, the bottom line is if legislation gives someone the authority to do something which might interfere with confidentiality of communications between the solicitor and client, The decision to do so and the choice of exercising that authority will determine with a view not to interfering with it, the solicitor-client privilege except as absolutely necessary in order to achieve the ends sought by the legislation. So yeah, good cases to help us protect our client stuff. Over to you, Catherine.
All right, well, I just wanted to say in respect of lawyers not authorized to practice, that note actually came up in my slide for litigation privilege. So that that is what I am more certain about. And I know, so I think it was asked in the context of solicitor client, or is that your understanding, Codie?
I can't remember. I know there's a rule though.
There is a rule, and we'll get to the bottom of it. So don't take what I've said as gospel right now. Just because it's a weighty topic. But moving on, litigation privilege, also known in cases as work product privilege. It was treated as a privilege of sort of lesser importance than solicitor-client privilege, but the SEC in a well-known case, 2016 SEC 52, clarified that litigation privilege, like solicitor-client, is a fundamental principle of the administration of justice. It is a class privilege, and it exempts communications and documents that fall within its scope from compulsory disclosure. So what it does protect is these documents, communications that are made for the dominant purpose of preparing for ongoing or anticipated litigation. The purpose of this privilege is to facilitate the litigation process. It operates and arises even in the absence of a solicitor-client relationship. So it applies to all litigants, whether or not they're represented by counsel, and to third parties who aren't involved in litigation. There's a test. It's established on a document-by-document basis, pursuant to this two-step test. So was litigation in reasonable prospect at the time the document in dispute was created, and if so, was the dominant purpose for its creation for use in litigation? So it's helpful to think about. We've used the imagery of the tin can with the string between the two tin cans. Litigation privilege is more like an umbrella. It can apply to documents that prior to becoming part of the lawyer's brief were public in nature. It's sort of much more easy to visualize as a type of umbrella. All right, some other points to remember. Really what it does is allows a lawyer a zone of privacy to prepare draft questions, arguments, strategy. It arises from the concept of that lawyers control the information that gets presented about their case. Counsel must be free to make investigations, do their research without risking the disclosure of their opinions. But important to note, really the document in question has to be prepared for realistically anticipated litigation. The anticipated litigation has to be real. It can't just be a possibility or a type of just a suspicion. That's, I think, all the notes I have to say about that. All right, now the scope. There is case law. There's a relatively recent BC Court of Appeal case that supports the proposition that litigation privilege doesn't only protect against disclosure to an adversary in the litigation, but it also can be used to resist an order sought by a third party to the litigation. And in this particular case, a plaintiff who was making a claim for charter damages against the RCMP sought production of an investigative brief that had been prepared by the RCMP in investigation or in anticipation of a criminal trial. And so that in that case, the BC Court of Appeal held that the rationale underlying litigation privilege couldn't be achieved simply by limiting its operation just to the litigation adversary alone. There's also a Alberta Court of Appeal case that we can provide the notation to as well. Moving on to exceptions. So it's litigation privilege. It's subject to clearly defined exceptions. There isn't a case by case balancing test. So the exceptions that apply to solicitor client also apply to litigation privilege. The evidence, if there's any evidence of a party's abusive process, that may constitute an exception. A very well settled exception is when privilege is waived during litigation. So when a party relies upon a document in question in open court. Other exceptions may be identified in the future. And then when does it end? Because the purpose of litigation privilege is to create this zone of privacy in relation to a pending or anticipated litigation. Once that litigation is ended, the privilege to which it gave rise to has lost its justification. However, when does litigation technically end? The courts have said, well, if the litigants or related parties are involved in what's essentially the same legal combat, it still lives. So courts have set out some things to consider as to whether litigation privilege is actually still alive. Is there an ongoing action involving the same or related parties? Does this action arise from the same or related cause of action? Are they raising issues that are common to the initial action, etc.? So it's a fairly complicated set of considerations that the person has to delve into. All right, moving on to informer for Codie.
Yeah, so informer privilege. So this is another SCC called it ancient and hollow protection. So it arises when a police officer in the course of their investigation guarantees protection and confidentiality to prospective informer in exchange for useful information that otherwise would be difficult or impossible to obtain. So it's an indispensable tool to deterrence, protection, prosecution of crime. Hubbard has in his book, and there's an American statistic that like 95% of drug crimes rely on informers. So your street level trafficking, wholesale traffickers, you got bad guys on the inside who are willing to give you information, for money, for whatever. But the promise of secrecy can be expressed or implied. There was one of these cases was just a woman who complained about her neighbor's kids maybe broke in and stole some guns, and she was a bit resistant because the family was a little bit crazy and didn't want to become a target for this family. So she was very reluctant to come, and there was, in her mind anyways, a promise of confidentiality, and she had talked a bit about being reluctant to come forward and she didn't want to make the complaint. And so the police didn't follow. They have an informer protocol. So there's internal practices there should be anyways, with police departments, RCMP, with how they deal with informers to try to protect them, because it's a circle imagery. Okay, it's an obligation owed to the informer by the Crown, the police, and the court. So they're within the circle. Defense counsel, who may be acting for the informer but may not know it, on the outside of the circle. So it can be applied in the circumstances. It applies to known and unknown anonymous informers. One of the leading case, Leapert, was one of those kind of Crime Stoppers type of tips. So nobody knew who the anonymous informer was. But because of the nature of and how broad in scope it is, all kinds of information, if we have any criminal practitioners here, you have your ITOs, all kinds of redactions, because even the smallest bit of information that could potentially disclose who the informer is has to be taken out of the ITO before it's given to the accused as part of disclosure. So it's really played a crucial role. The cases, so that was a 97 case. We have society, so CBCA, the CBC and kind of person designated 2024, SCC 2021. And another one here, I think was just a named person case, where the court is just hitting home every single time. There has been so many challenges to this, and the court comes back every time and says, no, it's broad. There's one exception, innocence exception. That's it. And everybody's like, well, full fair defense. No, Stitchcomb disclosure. No. After Sherman Estate, and they were coming, the CBC wanted the balancing test and Gigantus and the public interest and the open court principle. No, like every single time it is the same decision over and over again. This one has, I mean, every case is exactly the same. So it's really just these same three principles. It's not a complicated privilege. Where it gets complicated is how to protect the informer as you're working your way through the criminal justice system. If they end up being an accused one day, or they end up having to be called. And then how to protect their information in those ITOs. So how do we know who's an informer? Well, an informer is usually just a bad guy who comes forward with information. It's not what's called an agent provocateur, which is somebody who takes instructions from the police. So more your undercover agents, those wouldn't be informers, obviously, or just anybody who is somehow like following the police instructions. So the informer is someone just out there engaging in crime, comes forwards, as opposed to someone going with the police to like engage in crime. I don't know. I don't think they're allowed to engage in crime. Anyways, the privilege is jointly owned. It's belonged to both the Crown and the informer. So when it comes to waiver, obviously it's be very difficult to get waiver because you need both of them. And the informer usually is probably not going to want to waive their protection because then they'll be in trouble with the bad guys they have told on. So the editing process, it's the Garofoli step 6 of the Garofoli application, where the Crown can sometimes, stay the charges, or they'll do judicial summaries to try to supplement the redacted ITO so that the accused can make their Section 8 challenge, usually to the search, seizure, or whatever. So it's quite a process. We won't talk about it here. Sometimes some of these proceedings can be done in camera because the obligation is also on the court. And so there has been, not to the judicial officers, but the Crown and police have been sued in negligence for not properly managing informer privilege. That can give rise to, damages. That's what happened in that neighbor case, where once the family found out that she's the one who complained, they just harassed her. She ended up having to move, sell her house, buy a new house, and incurred all of this like emotional and psychological distress by being harassed and threatened by this family because she had told on their kids who had stolen guns, which is like a pretty serious, shouldn't have guns. Anyways, so yeah, it is common law. And so it has been extended in, so it applies to the police, it applies to some of these kind of like the securities investigators, maybe the CRA investigators, if they have like police-like powers. There was a recent case, a citizen in an immigration, was under the Immigration Act, where they were trying to CISA agents. So in the national security space, the court declined to extend the common law privilege, informer privilege, to sources to CISAs, but there was a statutory that kind of got them the same place, right? So early on, we had mentioned the parliament legislators can create statutory type privileges. So make sure kind of you're aware of that, because this was kind of, they wanted to go for the common law, but I guess they settled for the statute. But the CRA tipster stuff, that was all before this case. So I'm not quite sure. It was a 2014 Harcott, Canadian Citizen Immigration, 2014 SCC 37. So they came down a little bit more firm, probably because informer privilege is probably quite expansive and even more absolute than solicitor client privileges, because there's only one exception, guys: innocence at stake. So they've been a little bit more guarded in attempts to extend it. So,
where does the common law protection for securities legislation?
So this was a decision where the securities officers had all the same powers of the police officers. So in that jurisdiction, I think it was New Brunswick. So the investigators for the Securities Commission were basically police officers. So they were able to fall pre-Harcott under the informer privilege. Their promise of protection to whistleblowers, I guess, was given protection. Yeah. Okay. But I have a question mark, because I'm not sure. Post Harcourt, whether that still would be the same decision. Okay. Innocence of the accused at stake. So because in the civil, we're not dealing with the prosecution of the accused, so we wouldn't be dealing with they would never give way in a civil action. The test is kind of a McClure-Brown test. You've got the threshold that they have to meet before they can get to the substantive proof stage. All these tests in the criminal law, 4 stages, 6 stages, 7 steps. Okay. So the threshold question, this test is intended to allow privileged information only when it is shown the applicant has no other defense and that the request information would make a positive difference. And so it really is the last resort and when absolutely necessary. So this is where we've said as a society, the concerns with bona fide wrongful convictions override the privilege. Leopard, McClure-Brown, and then you have the 2-stage inquiry here. So you need an evidentiary basis to show that it could raise reasonable doubt, and then if they exist, the trial judge will determine whether in fact it's likely to raise a reasonable doubt. So here. So at stage 1, the evidence sought must be considered in conjunction with the other available evidence in order to determine its importance. The totality of evidence is what governs. So whether, I guess some of the notes from McClure basically say that when you're dealing with challenges of credibility or raising collateral matters, it will be difficult to meet the standard of stage 1. So once you get to stage 2, the trial judge is supposed to ask themselves the following question: is there something in the solicitor-client communication that is likely to raise a reasonable doubt about, or I guess the informer, because McClure and Brown were solicitor-client cases, to raise a reasonable doubt about the accused's guilt. So the judge doesn't have to conclude the information will definitely raise, because then you just be acquitting them. But they would, there would have to be nothing left. Instead, the information must raise a reasonable doubt as to the accused's guilt. Okay. Again, totality of evidence. Stuff. Okay, waiver. Waiver. 2-stage test. This formulation, I think, was this McLaughlin when she was still on the British Columbia Supreme Court. Yeah, S&K processors. So you know the existence and voluntary evidence and intention to waive it. You also have this, and we'll talk about it here, you can have kind of implicit waiver and partial waiver, maybe. If you're looking for, again, cases where they have a nice summary of the principles, it's an Alberta Court of Appeal case 2022 ABCA 136. So again, it's more akin to like a textbook, but it has all the footnotes, and it's both a majority and concurring decision. Okay, so express, right? So it's the client. The client must know of the existence of the privilege and voluntary evidence and intention to waive the privilege. So sometimes you'll see this during questioning where the other side will try to force you in the formulation of the question to try to waive privilege through a discovery. That's not them putting their state of mind or a waiver directly at issue. So it's you putting their privilege at issue is not what we're talking about here. This is where you have now decided I'm going to enclose these documents or produce them or whatever, because for whatever reason, this is what you need to make your case. So these should be very intentional, well-considered decisions. Inadvertent. Oh, sorry, Catherine, this is to you.
No problem. All right, inadvertent. So this is the one that sort of the sinking feeling in the pit of your stomach when this happens. Physical loss of custody of the documents. Generally, true inadvertent disclosure is not sufficient to cause waiver of privilege. Our codes of professional conduct set out what you must do if you receive privileged documents in error. The Code of Professional Conduct for the NWT Law Society, it's 7.2-10, inadvertent communications. Factors that a court will consider to decide whether the disclosure was inadvertent, whether privilege has been waived, for example, the manner in which the documents released, if there was prompt attention to retrieve them after this disclosure was discovered, the timing of the discovery of disclosure, the timing of the application to recover the documents, the number and nature of the third parties who became aware of the documents, whether maintaining the privilege would create an actual perceived unfairness to the opposing party, and then the impact on fairness of the court process. There's a 2021 BC decision where a document was redacted, but the attempt at redacting didn't, apparently they could see actually through the black lines or whatever had been redacted. So, but the court said even this effort at redacting, which wasn't sufficient, that, for instance, didn't remove the plaintiff's intent that this was privileged. All right, implied waiver. Waiver may be implied by the conduct of the privilege holder. So, for example, if a party advances a state of mind arising from legal advice or relies on legal advice to justify their conduct, waiver may be implied. But in these circumstances, again, going back to what Codie was saying, the privilege holder has to have voluntarily raised and for his or her own benefit, the issue of how he or she was influenced by this legal advice. The state of mind also has to be material to an issue in the litigation. So really, the party has to voluntarily inject into the litigation legal advice it received or its understanding of the law. It requires more than just a statement of a litigant's understanding of the law. And really what is asked is whether or not is it just on the basis of fairness and consistency to deny the privilege holder this privilege.
So we have, posed this question here, is there such thing as a partial waiver? Because, when you're making those very thoughtful decisions, this document or this part of the email or whatever, are you at risk of putting the rest of the communications or even a broader scope of documents at risk? And the answer to that question is yes. The court is very suspect to ideas of cherry picking, and they're not really willing or interested in parsing statements to be like, oh, well, that paragraph, but then not this paragraph. And so that's not really something they're willing to engage. And so what will end up usually, so be prepared, if this is a strategic decision, that you will be found to have waived privilege over all communications related to the same subject matter based on this idea of fairness and consistency, because sometimes we'll see this in the settlement privilege context where, well, first of all, both parties have to waive. But anyways, this one document and the other party will be like, but wait a minute, like that was one of 4 communications on the same topic, and makes me look like a jerk when you were the jerk, right? So you'll just be prepared for an outcome that you may not be all that happy with. But because this overarching idea of fairness and consistency is weighing in the background, that if you're taking one step, you may be pushed, a mile. So common interest privilege, just a little bit here where we have, it's a tent, umbrella, circle, now we're in a tent. We got a bunch of people under the tent. And so we've got British Columbia Court of Appeal 2007 BCCA 515, where we have numerous defendants sharing a common interest in defeating plaintiffs. So we have people working together. Typically, you should paper this with a common interest privilege agreement that sets out everybody's rights. you know, how far disclosure will, what happens if either side is faced with some sort of request to produce information, and the continuing cooperation, kind of, and a go forward. So, difficulty, of course, is when you guys now are in an adversarial position now, of course, there's no confidence communications as between, the group of you, so that kind of falls away. Okay, but it's not the same thing as a joint retainer, right? These are usually you would usually just have, you know, everybody their own sets of lawyers here. Catherine will talk a little bit about transactions where you can have, it's not just for joint litigation, but also for, you know, completing steps in some sort of larger corporate transactions. So, yeah.
Yeah, no, thanks, Codie. Yes, that's right. So this common interest privilege is expanded beyond the context of litigation or anticipated litigation. There is case law recognizing that parties to a transaction may enjoy common interest privilege, but there has to be an underlying privilege like solicitor-client privilege established first. And we've suggested that to maximize the likelihood that common interest privilege will attach when privileged information is being shared, you'll want to obtain some sort of a covenant or an undertaking of non-disclosure and confidentiality. Common interest privilege agreements are apparently now becoming a routine part of commercial transactions. Consider using one of those. Describe in any correspondence accompanying the documents the common interest between the parties and the need to exchange these particular documents to achieve that common purpose. Don't share privileged information or documents to a wider group than is necessary. So that's fairly self-explanatory. And we have a number of decisions here that would be helpful if this is something that you're wondering about further.
Yeah, just to that point, because we did have that request, Catherine. I think when we did the one for the BCCBA, we just went through and kept in our speaking notes the different case sites. We can.
I think
clean
so.
this-
Yeah, that's what we did. Yeah.
We can do that and circulate it to the attendees. So,
Yeah.
because there was a lot of cases we didn't even, you know, don't want to bore you to death with. In this case, this happened, and isn't that interesting? So, yeah, there's a lot of. But for the most part, I think both of us use Hubbard too quite a bit. So
Yes.
yeah, the
Hubbard
best
is the
place.
go-to.
Okay.
I have another question about that. How important is it to articulate what the common interest is if you're entering into an agreement? Because I've encountered situations where you may have a bunch of different issues arising in, you know, multi-party litigation, and you may have some things in common with some parties and you may not. And I've seen it where parties say, no, we really need to identify what the common interest is here, so everybody's on the same page. And I've also seen it where parties say, well, let's just kind of keep it vague because we don't know what's going to come up, and we want to ensure that we're maximizing our protection here. So, I don't know if you have any comment on that, really defining what the boundaries of the common interest might be.
Yeah, it's I don't have a sort of really definitive thoughts on that, but I guess it's just it's a sort of case by case judgment call. What would you say, Codie? I'm just poring over my notes here to see if I can see any comment from a court on that point, but not.
Yeah, so the only time I looked at a dispute amongst, so this became an issue when there was a dispute amongst the parties to the common interest later on. So it was a solicitor case. Parties were in a dispute about a contractual interpretation of a contract. The lawyer who drafted the contract, we came under it was weird why we were under common interest privilege, but I think everybody knew that there was going to be litigation between the solicitor and the client because they're the one who drafted it. And so if there was an issue there, we ended up getting a fight about the scope of the privilege in that context too, because I'm not sure that they really thought through what's going to end up happening later on, because the privilege should have fallen away, but depending on how the issues were, like if you're starting to get a little bit too refined, it ended up kind of being this issue. And so I ended up having to write a memo kind of extending the privilege over this because it was to try to get him under everything under the umbrella and then the umbrella to fall away. Based on how they had scoped that privilege. So they did a common interest privilege. Everybody had lawyers. The lawyer had a lawyer. And we were collectively defending against the other side in that litigation. But yeah, it did end up being a problem. So I don't know that there's one right way to deal with it. We just ended up having to fight about it later on because he was willing to do that. He wanted to do that exact same thing. We started cherry picking documents and we're like, well, screw that. Everything's going in now.
Interesting. Is it fair to say there's limited judicial commentary on the scope of common interest privilege?
Yes, I think that's right.
Yeah.
Well, because at the end of the day, it's gonna be a contractual matter, depending on how you draft it, right?
Yeah.
So there's no magic to it. So if you haven't thought through what was gonna end up the ultimate explosion later on, potentially between the parties to the common interest, it may end up being a problem. I'm not sure what ended up happening. This is a good thing about my job. Here's the opinion. Good luck.
Yeah.
Anything else? Any other questions?
Don't see him.
Okay, I think that's it. How about online?
Not
Anybody?
seeing any.
Okay, well, it was a very nice meeting, everyone.
Yeah.
Thank you.
Thank you.
And
Thank you, everyone.